Here we are, Professor Jeff Swartz and myself, and there's an awful lot of our population that's in jail or prison, right? And so that means there are a lot of people out there with loved ones, people they care about who are in jail or prison, right? And they're in jail or prison during a pandemic, where you and I have talked about this before, where these facilities are petri dishes for a disease like this that's so contagious, and so people are wondering what remedies are available to somebody who's housed in a jail or a prison, and particularly one that's infested with coronavirus. And you and I have talked before about two particular remedies that I wanted you to really kind of dive into. One is, I guess I'll explain some of the basics and then ask you how it works. But there's these two things that probably, and we're trying to make videos that people don't have to be lawyers to understand this. So these terms are going to be pretty foreign to most people. Writ of mandamus and writ of habeas corpus. Most people have heard of habeas corpus, but mandamus would be an order from a judge, and you should know because you were one, right? Mandamus would be an order from a judge directed to a government official to do a specific act that the person has a clear legal obligation, right, to do. Habeas corpus is more of the Hail Mary, where you're trying to actually get released, right? Where in the best case scenario for somebody who's detained. And so you and I have talked before, so I want to sort of throw this, ball over to you. It seems from our prior conversations that you think that mandamus is a much more likely, right, or much more potentially fruitful avenue than habeas corpus. So why don't you explain, technically, step by step, how this stuff works?
Okay, first of all, habeas corpus goes back to 1679 in England, when they created a mechanism under which people who were imprisoned improperly, or people who were being imprisoned incommunicado, for lack of a better way to put it, could find relief and gain release. We adopted habeas corpus in the United States very early on. In fact, it's in the Constitution, to the extent that the writ of habeas corpus can only be exercised for certain purposes, most of which we know during war, in order to maintain custody over POWs, for example. It's also for us to do acts which we now know we should not have done, things like the internment of Japanese Americans during World War II, when they were relocated to internment camps from the West Coast. The last time we used habeas corpus was actually in the George Bush administration, when they suspended habeas corpus as it related to civilians who were enemy combatants. In other words, they weren't the members of armies. And that suspension of habeas corpus still exists today. We still have people being held at Guantanamo, which is American territory, without having the right to a bond and having the right to be released or even tried to a certain extent. So that's what habeas corpus is. It technically means that the court issues an order demanding that the body of the prisoner be produced to the court, usually for the purposes of release. That is accurate. So that's
still be breathing, right?
Yeah, you got to still be breathing. It's not like, corpus delicti, bring me the dead body. Okay, so excuse me. So the writ of habeas corpus is, as you put it, a writ. It is an extraordinary writ. We have a number of extraordinary writs, quo warranto, mandamus, prohibition, are all extraordinary writs, which are technically a form of equitable relief. And in the criminal side of it, the two most used are mandamus and prohibition. Prohibition used to prevent the court from doing something that an appellate court or a reviewing court determines to be improper or illegal. Mandamus, as you put it, orders people to do certain things. Now, there are some people who have tried to get released based upon the danger that they face in prison from coronavirus, which, as you have said, are petri dishes, because once it's inside the walls, there's no way to get rid of it, and you can't distance yourself. You can't socially distance in a prison. So as a result of which, there are people, and they're famous people. I mean, I'm sure there are others, but the ones we know that have tried to get out, for example, Michael Cohen sought a release. That has been blocked for political purposes by probably the Attorney General himself, because Donald Trump doesn't want Michael Cohen released. The second one, for example, is Bill Cosby, who is sitting in prison, who is legally blind. He is 100 years old. Not really, but he walks like it. And apparently has other physical difficulties, and is basically saying, under the Eighth Amendment, this is cruel and unusual punishment. I was sentenced to a term of years. I was not sentenced to capital punishment. Both, or at least in his case and others that have sought this, are not getting their releases. They're not. We're not going to empty the jails, and they understand that by releasing somebody like Bill Cosby, who is considered to be a violent offender, now every violent offender is going to come in and claim an Eighth Amendment violation. So what do we do about it? First of all, we know that prisons and prison authorities have an obligation to provide adequate physical and medical care to those for whom the Bureau of Prisons, whether it be state or federal, have an obligation to protect. And they do have to protect their prisoners. So as a result of which, if they're not providing that care, then the question is, can they force that care? And obviously by a writ of mandamus, if a court determined that in fact the prisons are falling down on their obligations to protect, or the Bureau of Prisons, by what it does, is failing to protect the prisoners, then those prisoners would receive that mandamus, and it would require the states and or the federal government to do what they're supposed to do. And that's probably where the mandamus lies. There's also other means by which the Bureau of Prisons can do things to protect prisoners. They can start establishing cell blocks, doing periodic, if not daily, testing of every prisoner to make sure that the cell blocks become, for lack of a better way to put it, COVID ghettos, where those that are positive of COVID end up being in one cell block, while those, or barracks, or whatever, depending on the level of the prison, are housed. And those that are negative are kept away and segregated from those that are positive. Prisoners, obviously the workshops that they're in now have to be tested, because they could be spreading them through the workshops. All of the things need to be decontaminated. There's all kinds of things that the court could determine are appropriate things for bureaus of prisons to do under a writ of mandamus. And I truly believe that's probably where their greatest relief lies. Not necessarily, and we talked about this before, and we'll get to it in a moment, speedy trial issues, but as it relates to the housing itself. If a state or the Bureau of Prisons says they are not capable of protecting the prisoners, now you have a serious issue to bring forth on habeas corpus, and now try to determine what level of prisoner is to be released early. And I could see some states and the feds taking non-violent prisoners and either releasing them outright on community control of some sort, or actually putting ankle bracelets on them and putting them under house arrest, which is what the plan was for Michael Cohen. He was going to have to wear a bracelet and stay at home.
Right. So yeah, and I think one of the interesting things, and certainly you've hit on this, as the standard for relief under the Eighth Amendment, and there's another amendment that most people have heard of, right? The Cruel and Unusual Punishment Amendment. The standard in one of these cases, right, when it comes to medical treatment, it's only a violation of the Cruel and Unusual Punishment rule, right, if there is deliberate indifference to the medical needs of an inmate. Is that correct?
That would make it far more difficult for a prisoner to come forward and seek it, but at least it's less of an, how can I say, it's less onerous than trying to come forth on habeas corpus and claim that you're entitled to your full and total release, because courts are going to be very reluctant to do that. It's not a precedent that any court wants to set.
Right. Okay. Wait, now we only got a few minutes left, but yeah, let's hit on any remaining issues of how COVID or coronavirus COVID-19 is affecting what you mentioned, speedy trial, or any other impacts it's having on the criminal justice system.
Right. Speedy trial is one of those, and that is being handled in kind of a different way. The courts being, first of all, dealing with the federal statute, it is so loose and so dealt with by what we used to refer to as constitutional speedies, that it is unlikely that any court is going to find the prosecution was deliberately dilatory, or that the courts were being dilatory in bringing their cases to trial when they can't have jury trials. You just can't bring in juries, and you can't hold jury trials by Zoom. Okay, can't have deliberations by Zoom. Okay, and so as a result of which, there's just no jury trials going on. In the state courts, especially in Florida right now, we have a Speedy Trial Act called Rule 3.191, and we've discussed this before. And it basically has specific timeframes for when a case has to come to trial, assuming there's not been a waiver, that is a motion for continuance, or a delay that's attributable to the defendant. Those deadlines have now been extended by administrative orders of the state Supreme Court. So habeas corpus would never lie. That is not the relief you get for speedy trial in either court. What you get is writ of prohibitions, preventing the court from moving forward. That's another extraordinary writ. A writ from a superior court that says, I am prohibiting you from moving forward on this case because, or I'm prohibiting you from taking any act that which may and otherwise be legal for the court to do. And so they make that determination. Because of those extensions, that period, because of the emergency nature of it, all these, and it falls within the discretion of the court, of the Supreme Court of the state, all of those time frames, whether it's 150 days, whether it is 60 days, whether it is 50 days, whatever it may be, those time frames have now been extended. So when that 180th day comes up, or the 170th day comes up, now you got to add on all those extensions. And those extensions have now added on to 6 or 7 weeks. So you're really talking about, instead of 180 days, 222 days. And it's going to keep going like that. And I don't see anybody, unless there's a dilatory action where the state has specifically done something to extend it, which was not necessary, no one's going to get a speedy trial dismissal or a habeas corpus based upon the fact that their speedy trial has been denied.
Excellent. Okay, so I have maybe a minute left. So I just a quick summary on prisoners who are housed right now in jails, prisons, in terms of relief, right, that they might seek. It sounds like habeas corpus is not, at least a release, right, under habeas corpus is not a likely outcome. But we might see mandamus orders, right, coming from judges, basically trying to manage situations that are being mismanaged. Again, the Eighth Amendment standard will be deliberate indifference, and that's, as you said, that's pretty easy for the government to defeat, because all you have to show is that you're doing something, right, to try to manage the situation, and that means you're not deliberately indifferent.
Right.
Yeah. So. Yeah.
Yeah, I'm taking your temperature. Okay, I'm doing something, right? Okay, that's all it really takes. Okay.
I cared.
I really do. It's a deep feeling I have. Yes.
Right.
Okay.
Man. All right. Well, we're up against the clock, but that was great discussion. Thank you so much for sharing your knowledge of this stuff. As anybody who's been watching this knows, I don't have a Florida. I have a Michigan bar license, so I like talking to you, especially about how things are working where I actually live. So, and we're going to be back with more.
Welcome to Florida. Okay.
Yeah, 8 years later, 9 years, whatever it's been. But yeah, we'll be back. We're tossing around an idea, maybe talk about the Michael Flynn situation. So we'll have more, but that's good for this for today. So thank you much.
Always my pleasure. Have a great time, Brandon. Sitting around your house. Okay.
Oh, yeah.
Talk to you soon. Okay.
All right. Yep.
Bye.